Jody Lee Tibbetts, file number 247161FH. This time of day set for sentencing. Ms. Tibbetts is present, represented by attorney Andrew R. Lockard. People are represented by prosecuting attorney Timothy J. Rutkowski. On September 16th of this year, Ms. Tibbetts pled guilty to the following: discharge of a firearm toward a building, carrying a weapon with unlawful intent, carrying a concealed weapon. A pre-sentence report has been prepared by the Department of Corrections through their system on November 12, 2024. Mr. Lockard, have you and your client had the opportunity to review that report, sir?
We have, Your Honor.
Additions, deletions, corrections, or objections to the report, sir?
None of this, Your Honor.
You agree with that, Ms. Tibbetts?
Yes, sir.
And you've reviewed it as well, correct?
Yes, sir.
Okay. Mr. Rutkowski, any objections to the report as well as guidelines?
No, Your Honor.
Thank you. Any objections scoring the guidelines, Mr. Lockard?
No, Your Honor.
Thank you. What would you like to say on behalf of your client before the court is closed?
Thank you, Your Honor. I would note, and I'm not absolving or nor do I request the court to absolve my client, but of the two individuals in this case, her involvement was by far the lesser of the two. Again, that's not to totally just absolve, but to mitigate what she was involved with us. But you know, she has no. In her 40s, she has no prior record to speak of. A few years back, she had a cruelty to animals filed, but other than that, been clear sailing for her, as she stated, or as stated in the report. She does have strong family ties. In fact, I didn't realize this until I spoke to her at the time of this, but her stepfather actually used to be a neighbor. So I am familiar with him, and I would agree as far as that statement with her family. She's been a productive member of society up until this point and will be in the future, but you know, most recently her employment with Taco Bell, which was terminated due to this incident. But she realizes that, for lack of a better term, what happened really stupid on her part. Whether or not she was felt threatened, didn't feel threatened, wasn't sure what to do with the fact that he had a gun. There were other ways that could have handled that rather than just kind of I'm going to go with it. And you know, like I said, I'd be very surprised based on my conversation with her, based on her reaction, based on her interview with law enforcement, both at the time of the arrest but later on, that this is something you're going to be seeing her doing anytime. I hate using that phrase from the speech, so I'm not going to say anytime soon. It's not going to happen. So I would ask the court to adopt her.
Thank you. Ms. Tibbetts, is there anything you'd like to say?
Yes, sir. Your Honor, I take full accountability and responsibility for endangering my community by being an irresponsible gun owner. I made poor decisions in safeguarding my pistol, which ultimately led to a terrible crime that could have been prevented had I taken proper measures. I'm ashamed to admit that I was under the influence at the time of the incident, and I am aware that this could have been a more serious situation. However, I am truly sorry. Since my arrest, I have been participating actively 363 or 4 times a week. These meetings have greatly helped me to see a life without substance and to understand that I am not alone. I am building a support system of family, friends, and 360 when I am released. I understand I have to make better choices when allowing people into my life. I have been strengthening my faith in God as I have been attending church once a week and will continue to do so once I'm released. I am not a violent person, nor do I have a record prior to this. I am pleading with the courts to have leniency in my case. I am a work in progress, and I am learning from my mistakes. I am hoping for a chance to show the community and the courts that I can and will be a law-abiding citizen. And I am not a danger to my community. Once again, I would like to apologize.
Thank you. Mr. Rutkowski, anything to ask the people? This is a victim rights case.
Yes, Your Honor. We've spoken in the past to the victims in this matter. I say victims because the house in which the co-defendant had shot into that is Tibbetts had drove there, had 3 occupants. And the one up front was the father of the residents there. And of interest to the court is that the front area in which these rounds had gone into the house, I believe there was at least 2, maybe 3 that went into the house, was his bedroom area. He had certain things lying down the wall just because he lives in his bedroom. But for the grace of God, the rounds did not go all the way through because they found one, I believe, in a game box and another one that was in a dresser, but all about head high where he was laying in his bed at early morning hours sleeping. I would point out to the court, from the evidence in this case, what is clear is that the co-defendant and this defendant went into her bedroom where the gun was stored. They were in there for about a half hour, according to the victim or one of the testimony witnesses in the district court. And then they left. We have video from Taco Bell where this defendant works, where they go into Taco Bell. This defendant holds the door open for the co-defendant as he's taking the gun and shoving it in his pants pocket. So she knew at that point he had a gun. They went in there for the purpose of getting a charger, a phone charger. They leave there, and the timing from all the different cameras is they go directly from there to South Silver Street, where this residence was located. And so the court is aware the house that was shot at was not the house that was intended. It was 5 houses away. The house that was intended was this defendant's relative. And so, when you take that into consideration, and it's not just one shot, according to the ring camera that we have video from, this defendant drives down South Silver Street to the south. They stop, turn around, and head northbound on South Silver, fire 2 shots at the house. As you can hear, the ring camera also has audio to it. And then they go down further. This defendant turns around the vehicle and they drive back, 9 more shots at this house. So when you factor in that it's her car, you factor in it's her gun, you factor in that she knew that this defendant had this gun, and that they were driving down the street because her cousin lived on there and she knew where she was living, that she was on that street. We don't agree with the recommendation. I think if you look at the recommendation, this does not come from our local Department of Corrections. It comes from higher up. And the fact that we have a drive-by shooting here in Bad Axe that puts these people or any people in that street at risk demands that the guidelines be followed and that the guideline range of 23 months should be the sentence, 23 months to the maximum set by statute.
Mr. Lockhart, any other response?
Your Honor, the recommendation is within the guidelines. The guidelines are 10 to 23, 5 to 23, 5 to 23. So the recommendation is within the guidelines. I think it is telling that that it was, I don't know if the recommendation was done or at least signed off by a level up from this office, in so much as we have people that specialize in situations like this, I suspect, who then looked at it and said this is appropriate based on DOC guidelines as far as our recommendations. So I think that's one more reason to go along with or to adopt the recommendation that DOC has.
Thank you. Mr. Rakowski, remind me again, what caliber firearm was this? Is this a 45? Was it a 9
All the way to
millimeter?
9. I know, I believe I could look again.
Oh, that's fine. That's fine. Well, I think we were, just me personally, my family, we were just camping here in Huron County, and all of a sudden this hits the airwaves. And you get approached by other individuals that, wow, a drive-by shooting here. I mean, you don't hear that in this community. Knock on wood. And it's scary. It's downright scary. Numerous people were placed in danger. I believe there were 5 people in that home, which was the wrong home that was shot at. There were 2 shots on the first swipe, 9 shots the second time. There were bullets that did enter the residence, and it was all over a verbal confrontation with a cousin, is what it gets down to, is what it really comes down to. And to me, and to this court, we don't see this type of behavior in this community. Now, in the other communities outside of the Tri-County area, the larger communities, you do see this happening, and they have specialists within the Department of Corrections that make recommendations like this. And certainly there may be a reason for it. When I read the recommendation, no disrespect to you, Ms. Tibbetts, I thought to myself, you gotta be kidding me. Frankly. Guideline range is properly scored at 10 to 23 on count 1, 5 to 23 on count 2, and 5 to 23 on count 3. I say the counts, but I believe they may be in separate counts here. They're 1, 2, and 3. And that means under the sentencing guidelines that the court is to consider 10 to 23 would represent the low term of the sentence to the maximum. So in other words, count 1 is a 10-year maximum. Sometimes people think, well, just give this person 10 years. Well, the law prohibits that. There's not only the guideline range the court has to consider, but under People versus Milborn, the 2/3 of the maximum sentence. So when you see guidelines of 10 to 23, that means the court could give county jail, which is recommended in each of the counts, or the court can go as low as 10 months in prison to 10 years, or 23 months in prison to 10 years, or anywhere within that range is count 1. And the behavior, and Ms. Tibbetts stated that she was under the influence at the time, but I know people that consume alcohol and do other things, consume other substances, and when they do so, they may drive, they may get into a verbal argument, they may go to bed, they may just be quiet. But there are some people that hand a firearm to another individual and commit these crimes. To Ms. Tibbetts' credit, she did not pull the trigger according to her testimony. That's all the court has at this point. However, she did provide the firearm. She pointed out the residence, which was incorrect. And here we are today. And I respectfully disagree with the recommendation by Lansing in this case as well. Now, to Ms. Tibbetts' credit, she has 1 prior misdemeanor, and she did state she doesn't have anything, but I thought there was 1 prior misdemeanor. I'm going to check this here. Yeah, the animal charge. It was brought up earlier. And that was back in 2019. So she's paid her debt to society regarding that, but that does show that she has 1 prior misdemeanor, and that's it. It will be the sentence of this court, though, considering the danger to the individuals, the residents, the danger to the community, and all of that, but it's within the guideline range. As to count 1 in this case, the defendant will be committed to the Michigan Corrections Commission and placed in their custody for a period of minimum term of 20 months to a maximum of 10 years, credit for 135 days served, crime victims assessment of $130 will be ordered. Attorney fees are waived, $60 DNA testing fee will be ordered, $68 in state costs will be ordered. As to count 2 of carrying a weapon with unlawful intent will be the sentence of this court. Defendant be committed to the Michigan Corrections Commission for a minimum term of 20 months to a maximum of 5 years. Again, credit for 135 days previously served, $68 in state costs will be ordered. Count 3, carrying a concealed weapon, guideline range here is 5 to 23 months. Again, like sentence, 20 months to a maximum of 5 years. Credit for 135 days served. $68 in state costs will be ordered in this case as well. Now, there may be some individuals out there that say, hey, That's way too light. How can you just give someone a minimum prison term like that? Again, the court has to consider the guideline range. And the court is considering the guideline range, and based upon the severity of the charges, based upon the defendant's prior history, the court finds the sentence to be appropriate. By duty to inform the defendant, she has the right to seek leave to appeal. If she's financially able to provide counsel of her own choice, court will assign counsel for a public expense. If she's to initial receipt the questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days, and all sentences shall be served concurrently with each other. Mr. Rukowski?
Will the court entertain leaving restitution open?
You know, that's right. There
We haven't
was
received anything, Your Honor, but,
something
no
about
damage.
6,000, I believe.
oh, okay, it might be in the other file then, but the restitution amount, but if the court could leave that open.
You're correct, Mr. Rukowski, and I appreciate you providing that. Restitution also be left open if all three counts. Good luck to you, Ms. Gibbons. That'll be all.